Welcome everyone to our webinar on trusts. It's an exciting topic. Must be an exciting topic because it's our largest registrants in our webinar history. We started these back during COVID. So I want to welcome you to Andrew Rusniak, Bill Engel, and myself. Just a quick little upshot on Fort Pitt Capital Group. We were founded in 1995 as a registered investment advisory firm focused on fiduciary advice. So we're giving advice based on what's best for our clients. And it's a real niche market that we serve. And we do everything in-house. All of our financial planning is in-house. All of our investment management is in-house. I'm very proud of that. Work in a very boutique feel, but we do have a large company resource behind us, manage about $5 billion in assets. Quick little upshot on our webinars. One thing we want to highlight is that we're not just investment managers. We do provide a lot of advice, and it's not just financial. Sometimes it's about estate planning. Sometimes it's about taxes. Today, we're going to talk about how trusts may play a part in your overall financial situation. A little bit about me. My name is Bryson Roof. Been in the industry for roughly a little bit more than a decade, certified financial planner, and outside of investment advisory work, do a lot with beagles, raise them, train them, trial them, and actually have the first AKC National Grand Champion and Field Champion. And I am expecting a daughter in February. Looks like my mic went out, so I'm going to just switch over cameras. Excuse the technology glitch. And I am expecting a daughter in February, so we can talk about how trust may play a part in that role. Bill, why don't you give a little bit about yourself?
Sure, thanks, Bryson. So Bill Engel, one of the senior advisors and partners here at Fort Pitt Capital Group. I'm coming up on 10 years with Fort Pitt Capital. Been in the industry for about 20, and live here in Pittsburgh, born and raised. Live here with my wife and 3 children, 2 of which are becoming young adults, and one who's my youngest is 18. So again, for estate planning purposes, there's some things that I'll ask Andrew about. For fun, I like to spend time with my family and friends. I am a average golfer and enjoy doing some brain teasers as well. So that's it for me. Thanks, Andrew, for joining us. Again, as Bryson said, this is a really captivating subject, I think, for our clients and prospects, and a lot of mystery around trusts. And so we're excited to learn a little bit more today.
Our featured guest for today is Andrew Rusniak, a close personal friend and a great referral source for the firm. Andrew's works out of Lancaster and Harrisburg, but McNees also has an office out in Pittsburgh. So happy to work with all of our clients, no matter what location you're in. And Andrew specializes in estate planning and taxes. He actually has his LLM in taxation with a certification in financial planning. So we'll let Andrew take over the show in a minute. I just want to do a little bit of general housekeeping. If we were at a live presentation, this is where I tell you where the bathrooms are and where the coffee and tea is, but you're at home, so you know where that's at, or you're at your office. So if you're joining us via a mobile device, you can interact with us you can see kind of a screenshot of a cell phone, bottom right-hand corner. Happy to ask any questions or answer any questions. On a computer, it's a little different, but still the same general theme. You can get our handouts and ask any questions. And if you're having a hard time seeing this screen, there's a red button at the top left corner of that dialog box. Hit that, it'll pop it out, and you can access the questions and the handouts. So without further ado, Andrew, maybe we can let you start talking a little bit about trusts You know, I think a lot of times when we're talking with clients and prospective clients or people on the street, they feel that trusts are this magic silver bullet, and maybe they have some misconceptions or myths associated with them. So maybe you can take over the reins and tell us about trust.
Yeah, no, that sounds great. Thank you to Fort Pitt for having me. My name is Andrew Rusniak. I'm a partner with the law firm of McNees Wallace Nurick, and as Bryson mentioned, I practice in tax, trust, and estates work. So I'm an estate planning attorney. So what I do all day, every day is work with families, really on the personal planning side of things. So work very closely with Fort Pitt and the team there. You know, estate planning isn't something that you do in a vacuum. It really ought to be something that you work with your financial advisor on, as well as your accountant. Everything that we do is related. So what we want to talk about today for the next about hour, 50 minutes or so is trust. We could do a lot more on trust. I actually also teach a course at Dickinson Law School called Wills, Trust, and Estates. So we could do a semester's worth on trust, but we're going to boil it down here for the next 50 minutes or so. Do want to save some time at the end for any questions, so please feel free to fire away with those. But my goal, my hope, is that we can leave the presentation with a pretty good understanding of at least what are trusts, how might they be relevant to your particular situation, and maybe shed some light on a topic that you know, most people who don't live in our world have a whole lot of information about. So let me see if I can go, here we go, to the next slide. So, you know, what are we going to talk about today? Trusts are a piece of the estate planning puzzle. They are not always a silver bullet. They're one tool in the toolkit. And so I want to sort of start by setting the table for us and understanding when and how trust can be useful and relevant in an estate plan. You know, when we think about estate planning, it is very state specific. We'll talk about this and what that means as we go through. This conversation, this presentation is primarily going to be directed towards Pennsylvania residents. So the state that you reside in is the state that will control the administration of your estate if and when you were to pass away. Some of what we'll talk about is relevant anywhere that you're located, but it's important to understand that, you know, good, solid, recommended planning for a Pennsylvania resident may look different than solid estate planning for a Florida resident or a California resident. We'll talk a little bit about why that is, but what I would say is I wouldn't necessarily start your trust research just from Google, because any article that you read, it may be written for a different audience, right? If you're a Pennsylvania resident and you're reading an article that's sort of written generically or for a California audience or Florida audience, you know, don't necessarily assume that it's relevant to your particular situation. So it's important to work with your attorney and your financial advisor as you're updating or putting into place any trust structures. Just, you know, make sure you know what problem it is that you're trying to solve for. So just to sort of set the table, when we think about estate planning and trusts, and this conversation really is mostly about trust, but when we think about core estate plan documents for a Pennsylvania resident, there are really 3 and sometimes 4 main documents that sort of everybody ought to have as a part of good planning. The first 2 are fairly straightforward. The first 2 are your financial power of attorney and your healthcare power of attorney. Not going to spend a lot of time on these because that's really not the purpose of our conversation, but a financial power of attorney is a document that names an agent to manage your financial affairs for you if you couldn't do it for yourself. So your agent can sign your tax returns, pay your bills, talk to the Fort Pitt team on your behalf if you couldn't do it for yourself. The healthcare power of attorney and living will are very similar, except obviously deal with making medical decisions for you. The way that it works is that when someone passes away, those powers of attorney go away, and that's when your will comes into effect. And your will is the document that controls the disposition of your individually owned assets. A will does not control any jointly owned assets. It does not control any assets with a beneficiary designation. So as we're thinking about estate planning and leading into trust, we want to make sure that all of your assets, regardless of what type of asset they are, we want to make sure everything is coordinated and works together. You know, we don't want one IRA beneficiary designation going off over here and having your will say something else. We need to make sure that everything is coordinated, which is why it's so important for your attorney and your financial advising team to work together. But as we think about wills, wills are oftentimes the first place that we see trusts. Wills are commonly used to house trust provisions, especially for minor children, right? So when we think about a trust that's contained within a will, we call that a testamentary trust. A testamentary trust is a trust that's contained within a will that does not come into life or come into existence until you pass away. And it's very common to see, I have 2 children myself. They're 7 and 3 years old, 2 little girls. And my will says that anything that would pass to my 2 girls until they turn age 30 will be held in trust for them. We're going to talk about what a trust is, but a trust is simply a vehicle to hold property for the benefit of a beneficiary, pursuant to whatever terms we write down. So the testamentary trusts that are in my will for my daughters say that if they're under the age of 30, they would have the right to have access to their trust for their health, for their education, for their maintenance, and their support. You commonly see that terminology referred to as a HEMS standard, health, education, maintenance, support standard. And what I usually tell folks is, it's all the stuff that you as parents would otherwise pay for. Your children will still have access to it for those same things. So whether it's tuition or money for rent or a down payment on a house, money to provide funds for a first wedding, usually not a second or third wedding, but usually at least for a first wedding, the trust beneficiaries, your children in this case, would always have access to it for those things. And they'll have access to it via the trustee. So the trustee manages the trust for the benefit of the beneficiaries. And again, wills are usually where we first see trusts, and oftentimes it's just simply to get a younger beneficiary up to a more mature age before we shut it down. In this case, it doesn't require a separate standalone trust document because the terms of the trust are contained within the will itself. And that will, if we're talking about minor children, would typically also name guardians for minor children. So in Pennsylvania, the age of majority is 18. We would need a guardian for their physical well-being, but the trust is going to manage the financial piece for them, right? Oftentimes, yeah.
Andrew, sorry to interrupt, but so my children, a little bit older, when I created my estate plan, they were young minors, but now my youngest is 18. Do you think it's a good idea for folks around my age or in situations similar to mine to review that estate document and see if when's a good time to either remove the testamentary trust or what kind of considerations as your children kind of age out?
Yeah, it's a great question. I always tell my clients, estate planning isn't something that we do once and we're forever done. These documents don't have expiration dates on them, but your life will change and your children's lives will change as time marches on. So it is important to review and update these things as time goes forward. I usually recommend that you pull out your estate planning documents every 3 to 5 years and at least read them and just sort of, think about whether or not they're still appropriate for your situation as drafted. So, when we're thinking about, young children, minor 7 and 3, I hope that they're the most responsible 18-year-olds that we've ever met, and I can take out those trust provisions down the road. But I don't know what they're going to be like or what they're going to be dealing with. So what we do is we put on paper something that's reasonable, and then we just update it, as time marches on. The slide on the screen here says, or has an example of a trust that would last until age 35. And what it says is that the beneficiary would have a mandatory right of withdrawal at age 25, the ability to pull out half at age 30, and the balance at 35. Every situation is going to be a little bit different, but I would suggest that, as your kids get older, maybe even as they're young adults, you just have a conversation to say, is it still relevant and appropriate for them? And it very well may be. They may be responsible 18-year-olds, but maybe we like the idea of someone or some entity still being there to manage the assets for them, make sure that they're invested appropriately, make distributions at the right times and for the right reasons. But another thing that we'll talk about later on is that trusts are creditor protected. So even if you have a beneficiary who's 18 or 19, if that beneficiary, heaven forbid, caused a car accident and got sued, or went through a divorce, as long as that trust is in existence, the trust assets serve as a safety net for the beneficiary and would be protected. So, it's pretty common to see, something out to age 30 or 35. But, as time goes on, you can sort of reassess whether it's appropriate as you watch your children get older.
Thank you.
Andrew, just real quick, we have a lot of questions rolling through, so I just want to make sure that we're answering people's live questions. One question's going to be about some asset protection that we'll address later in the seminar, but there's another question that says, what's the difference between a pour over will versus a testamentary trust? And we often receive that question. We often have to plan things out based on life events. And
Yep. So it's a great question. We have, at this point, we have not yet talked about standalone trust agreements, whether it be revocable or irrevocable trust agreements. What we've talked about so far is a will that may contain testamentary trust provisions for a beneficiary. All of those trust provisions in this example are contained within the will itself. A pour over will is a will that works hand in hand with something called a revocable trust agreement, which is on one of our next slides here. We're going to talk more about revocable trusts. But a pour over will is simply a will that says, take all of my assets that I own and pour them over into my revocable trust. And the terms of that revocable trust contain all of the dispositive terms for the estate disposition at that point. So a revocable trust, and we'll talk about when it may be useful and when it may be helpful, is a document that works hand in hand with your will. So you'll never have a revocable trust without also having a will. You'll always have that pour over will in that example that would pick up anything that might be remain titled in your personal name that might be an estate asset. And a pour over will simply pours over the assets into the revocable trust for later disposition pursuant to that document. Okay. So just some trust terminology. When I teach my students at Dickinson Law School, I hammer on them the fact that the all terminology in this world is really important because different terms have different meanings. A trust is, again, simply a vehicle to hold property for the benefit of a beneficiary pursuant to whatever terms the creator of the trust writes down. The settlor or grantor of a trust is the person creating the trust. So the grantor is the creator of the trust. The trustee manages the trust for the benefit of the beneficiaries. And the trustee has legal title to trust assets. What that means is that any investment account or piece of real estate that's a trust asset is not titled in the personal name of the trustee, it's titled in the name of the trust. And the trust owns the investment account or the real estate or the bank account, and it's managed by the trustee for the benefit of the beneficiaries. We say that beneficiaries have equitable title to trust property. All that means is that the trustee holds trust property in a fiduciary capacity for the beneficiaries. So it is the beneficiary's property subject to the strings that the grantor or settlor has put on them. Trust property can be anything. You can put anything into a trust. You can put real estate into a trust. You can put cash. You can put publicly traded securities. You can put closely held securities like a business into a trust. We'll talk about when that might be relevant and why you might want to do that, but a trust can hold anything. The only thing that you cannot put into a trust really is a retirement account. Now, you can name a trust as a beneficiary of a retirement account, but you can't gift your IRA while you're alive in its IRA format into a trust. But you can name a trust as a beneficiary of your IRA.
And when would you do that?
Would you say when would you do that?
Mm-hmm.
Yeah, so in my example, for my two kids, I have a retirement account. I would not want to name my children themselves as beneficiaries of my IRA if I passed away. I'd want to name their trusts as beneficiaries. And we said earlier that retirement accounts and insurance are controlled by beneficiary designation and not by your will. So I would want to update those beneficiary designations to be coordinated with my will and direct those accounts into my kids' trust if something were to happen to me. So we want to make sure that all those beneficiary designations are coordinated with the overall estate plan.
And I know from personal experience, whenever you're doing an estate plan, you always give a little checklist that says, have you updated your beneficiaries?
Yep. And I always provide the language to my clients to do it. I give them sample language to say, here's what I suggest you write into your beneficiary designations so that it is coordinated with the rest of your planning documents. Yep. The last one on here, trust instrument or trust agreement, that's just a governing document for a trust. It's the legal agreement between the grantor and the trustee as to how the trust is to be administered. Okay, so those are just some terms to be aware of. I'm a visual.
Pardon me, I think you answered this, but we did get a question. Can I put an LLC into a trust?
Yes, yep, a trust can own an LLC. It can own stock in a company. It can own a partnership interest in a partnership. A trust can own anything that an individual could own, could be housed inside of a trust. Absolutely. Yeah, I'm a visual person, so I just sort of like to see this visually. This is just a visual description of what a trust is. The grantor transfers real or personal property into a trust. It's managed by the trustee for the benefit of the beneficiaries. And the trustee has the ability to make distributions to the beneficiaries out of the trust for whatever terms we write down. Bryson, can you go to the next slide? I'm not able to advance this. There we go. So a trust, again, a trust is just a property arrangement in which real or personal property is transferred from the grantor to one or more trustees to hold for the benefit of the beneficiaries who hold equitable title. So that trust agreement is really important because that lays out the terms of the trust, and that's sort of the roadmap for the trustee to follow. There's different types of trusts. Most folks have at least heard of revocable or irrevocable trusts, and those are the two main flavors of trust. There's revocable trusts and there's irrevocable trusts. If you're thinking about establishing a trust or incorporating a trust into your estate plan, my best recommendation is always, figure out what problem you're trying to solve for, and maybe a trust is a solution for it. I'm not one to sort of jump into saying, everybody needs a trust. You may need a trust, but let's know what the reason is for it, and then put it into place from there. So a revocable trust is just what it sounds like. It's a document that can be revoked, it can be amended, it can be changed. I usually describe a revocable trust agreement as simply an extension of your will. So in the pour over will example that we talked about a minute ago, the revocable trust works hand in hand with the will to receive the estate assets that get poured over into it. And then the terms of the disposition for the benefit of the family are contained within that revocable trust agreement. They're very flexible because they can be amended and changed at any time. Typically, the grantor is also the trustee of the revocable trust while living, and also the beneficiary. If I retitle my bank account or my car into the name of my revocable trust, it's sort of like I took it out of my right pocket and put it into my left pocket. It's still all mine. I can do with it whatever I want. But why would I want to do that? What purpose does that serve? There are some times in some places where probate avoidance is an important consideration. Probate is just the process of transferring assets out of the name of an individual decedent to the beneficiaries. In Pennsylvania, we have what's called unsupervised probate, which just means that once your executor is appointed by the filing of a probate petition, they don't have to go back to court for anything unless there's a problem of some kind. So in Pennsylvania, estates can be settled without court oversight. It's not that way in every other state. So in places like Florida and California and Connecticut and some other places, they have what's called supervised probate, which means that the executor has to get court approval to do almost anything, whether it's pay bills or make distributions or sell real estate. You have to send your lawyer off to court to go get a court order to do those things. And that gets time consuming and quite honestly gets expensive. And so in those places, you want to avoid probate. You do that by establishing a revocable trust and transferring all of your assets into that revocable trust. They're still all your assets. You can sell them, you can use them, you can spend them, you can do whatever you want with them. But because a trust never dies, there's never a need to go through the probate process when that person passes away. So in those places where probate avoidance is an important concern, you fund a revocable trust, and you can avoid probate if you get all of your assets retitled into the name of the revocable trust. If you miss one asset, if you don't retitle a bank account or you don't retitle a car, you're still going to have to probate to go collect those assets. So if your goal is to avoid probate, make sure that you've retitled all of your assets into the name of your revocable trust.
Andrew,
So,
I really appreciate that explanation, because I won't speak for Bryson, but personally, in my professional experience, probably the vast majority of inquiries I've gotten about whether I need a trust, it's to avoid taxes or avoid probate. And a lot of times it's not an informed question. It's really, you know, people will tie themselves into a pretzel to avoid taxes or avoid probate, and without really understanding what those taxes or costs might be.
Yeah, no, I think that's right. I think that goes back to, you know, the Google article discussion earlier. You know, there's a lot of articles out there that's, you know, you have to avoid probate. You know, it's fair and it's expensive, and it depends on where you are, and it depends which probate system you're subject to. You know, Pennsylvania, fortunately, you know, we have unsupervised probate, and it's not a process that most Pennsylvania residents will jump through hoops to try to avoid. It can be relevant, and there are some times in some situations where it's relevant in Pennsylvania, but for the most part, you know, we're not doing everything and anything that we can to avoid probate here. But that's why I say it's sort of an extension of a revocable trust is an extension of your will. It does not provide you, revocable trusts do not provide you with creditor protection. So if I can put property in and pull property out and it's still all mine, the way that the court system and the law looks at it is it's still all yours, even for your creditors. So a revocable trust does not provide creditor protection to anyone.
And
also, yeah.
One of the big things that I often hear, you know, I get the same question that Bill gets frequently, but it's, well, what about the privacy? I don't want everyone to be able to see the probate.
Yeah, that's a great question. That sort of falls under one of my myths that I have listed up here. People say, you know, I don't want my will to be a public record, which it is. You know, public, it gets filed when you pass away, it gets filed with the Register of Wills office in the county that you live in. And anyone can go pull your will if they wanted to walk themselves into the courthouse. And so they say, well, I'm gonna do a revocable trust instead, so that nobody can find out, you know, what my estate plan documents say. All that I'll say is, if you know what you're doing, you can still access someone's revocable trust. So a revocable trust gets attached as an exhibit to the Pennsylvania inheritance tax return. The Pennsylvania inheritance tax return is a public record. So even if you have a revocable trust in Pennsylvania, it is still technically possible for someone who knows what they're doing to be able to find it and access it. So yes, it puts in one maybe additional barrier because you have to pull the inheritance tax return to be able to get it, but it is possible. So if your goal is ultimate privacy, there's some other things that you may want to, there's some other ways to get around that, but the inheritance tax return itself is a public record. So the privacy piece is, it's not absolute, we'll put it that way. So, you know, when might we want to have a revocable trust, even for a Pennsylvania resident? I have up here, it says standard federal estate tax planning. Some folks might be familiar with what used to be called AB trusts or credit shelter trusts and Q-tip trusts. If we're going to have trust provisions that last for a long time, right? If we want to have a trust that lasts for the lifetime of a beneficiary, or it's going to last for multiple generations, my personal preference is to house those long-term trust provisions inside of a revocable trust. So I don't need to write you a 75-page will that, you know, 50 years from now, it doesn't matter who your executor was. It doesn't matter that you gave $25,000 to your local United Way. All we really want long-term going forward is a separate standalone document that houses the trust provisions for somebody. And so I'll typically, if I have longer term trust provisions that are going to go on, I'll usually house that inside of a revocable trust. If I have out-of-state property, I may want to house my out-of-state property inside of a revocable trust. So I said earlier that the state that you live in when you pass it away is the state that controls the administration of your estate. So Pennsylvania controls it for Pennsylvania residents. The one caveat to that is that every state in the country has an interest in controlling the process by which real estate gets moved around within its own borders. So if I have a property in New Jersey at the shore, New Jersey is going to control administration and the estate process with respect to that property. So if I die a Pennsylvania resident, my executor is going to probate in Pennsylvania for primary estate administration. They're also going to have to probate in New Jersey for ancillary probate administration. In some senses, you are doubling up on your estate administration work at that point. And so oftentimes I'll have clients own out-of-state property in a revocable trust, because again, a trust never dies. There's never a need to probate in that other state. So a revocable trust could be really useful there too.
And Andrew, is there any transfer tax associated with that?
It's going to totally depend on the state. Most states have exemptions for property going into trusts. But depending on the state, we'd want to be careful. We want to be mindful of that before we moved it in. Yep.
And I think that kind of lends itself to, we just had a question where someone asked, who do we talk to when we want to set up a trust? Do we talk to a tax attorney, a estate planner, financial planner?
Yeah, typically an estate planning attorney. Certainly financial advisors can be helpful in guiding you through that discussion. But quite honestly, only lawyers can write legal documents. So, usually it would be, your estate planning or tax attorney that would be able to help you with that. So that's revocable trust. We'll talk more about it, but that's revocable trust. Irrevocable trusts are just what they sound like. They are irrevocable, so they are not nearly as easy or flexible if you wanted to change something for them. An irrevocable trust is typically used for tax planning purposes. We'll talk more in a couple of minutes about what those taxes are, but usually what we're talking about there are transfer taxes or taxes of death, like estate tax and inheritance tax. Typically, we use irrevocable trusts for tax planning, but irrevocable trusts are also great for creditor protection. So an irrevocable trust is creditor protected for its beneficiaries. So the law in almost every state is well settled that a creditor of a beneficiary cannot force a distribution to pay the claims of the beneficiary out of an irrevocable trust, right? So we'll talk a little bit more about that, but irrevocable trusts are typically creditor protected. Now, I can't create my own irrevocable trust and get creditor protection. So I can't take Andrew Rusniak's bank account, put it into the Andrew Rusniak trust, and just call it irrevocable. That we would call that a self-settled trust. Pennsylvania does not allow for those. There are about 13 states that do allow for creditor protection for self-settled trusts. That's a very different discussion. There's a lot more hoops that you have to jump through. But when I'm talking about funding a third-party trust, a trust for my daughters, for example, or my grandkids in the future, because they're not self-settled, the law does respect the creditor. So if I have a child who I'm concerned about their liability risk, maybe they're in a high-risk profession, maybe they're a surgeon, or maybe I'm concerned about their marriage falling apart. If for whatever reason I may be concerned about someone's creditor issues, an irrevocable trust is a great option for somebody like that because it does provide that protection. The last point on here, inter vivos versus testamentary. We talked about testamentary trust. That's just a trust that's contained within your will. An inter vivos trust is a trust that you would create during life. I just want to lay out those terms so if you see them, you know that's what the distinction is. So we talked a lot about revocable trusts already, but again, they're extensions of your will. You can fund them during your lifetime. Typically, you can put property in, you can pull property out. It's still all yours. They used to be called living trusts more often. You can still call them living trusts, but it means the same thing. A living trust is simply a revocable trust. Just like I can update my will, I can update my revocable trust. But again, it does not provide me with any creditor protection. It does not avoid death taxes. Again, because it's revocable, it's still all mine. It does not provide me, it does not get it out of my estate for tax purposes. It only avoids probate if you get all of your assets titled into the name of the revocable trust. So that does mean that I have to retitle my car and my bank account, everything out of my name into the Andrew Rusniak revocable trust. If I do that, I do avoid the probate process with respect to those assets, but only if I get everything in there. And then we talked about the privacy piece. So the revocable trust is an attachment to the Pennsylvania inheritance tax return.
Andrew, just before we move on, for revocable trust, we often get questions about, I'm worried about my funds going to a nursing home because I'm sick or my spouse is getting sick.
Mhm.
Based on the creditor protection provisions within a revocable trust, that would not protect from a nursing home.
Correct. A revocable trust will not provide you with nursing home creditor protection. No. Again, if it's revocable, the law looks at it as if it's still all yours. So it's not a separate standalone creditor protected entity. It's still all yours. Yep.
Yeah, that's a confusion or a conflation that a lot of clients have. They kind of want their cake and eat it too. They would like to retain control and ownership of assets, but avoid the liability or be able to protect them. And as I tell people a lot of times, I don't think that's going to do what you think it's going to do.
Yeah.
And Andrew, we got one more question about revocable trust. So if you have revocable trust or you have a living trust, does that help with two questions? One, in a special needs capacity, if you're the legal guardian, would a revocable trust help with that? And also, how would that look for incapacity? Do we still need powers of attorney, or does a living trust suffice?
Yeah, it's a great question, and that asset management can be a great reason that we fund a revocable trust. So if I take all of my assets and I put them into my own revocable trust, the terms of that revocable trust might say, to the trustee, provide me with whatever I need for the benefit of my lifetime, but maybe I'm also caring for my adult special needs child, right? Maybe I'm also having to supplement their income or provide for them in some kind of way. They can be a beneficiary of my revocable trust while I'm living as well. And so if I get to the point where I can't manage my own finances anymore and I resign my role as trustee of my own revocable trust, then my successor trustee can come in and step in and manage my assets the same way that I had been doing. So it works very much like a financial power of attorney in that way, but the trustee has control of trust assets. So I have plenty of clients who they get older and they're not able to manage their own financial affairs. And sometimes a revocable trust is a great way, because as soon as they resign or step down as trustee, the successor trustee already has access, has the ability to manage trust assets moving forward under the same terms and conditions that I had been doing it, as long as I wrote it that way.
And that trustee has that fiduciary obligation.
Yep. Yeah, so a trustee is a fiduciary, meaning that they're subject to the highest duty that the law imposes on a person. They cannot just start spending assets for their own benefit. They are accountable for the things that they do. They have to keep records of the things that they do. So, yep, a trustee is a fiduciary in that way. We talked about when you may want to use revocable trusts. Again, for longer term, dynasty trust. A dynasty trust is just a trust that never ends. It could benefit my children and their children and my grandchildren, sort of so on and so forth in perpetuity. So if I'm gonna have longer term trust provisions, I may want to have a revocable trust just to house those trust provisions so that I don't have to keep them in my will. Again, real estate located in another jurisdiction, if I want to avoid that ancillary probate, I may want to retitle that out-of-state property into a revocable trust. So just going to talk a little bit about taxes, because we're about to shift gears and talk about irrevocable trusts. Again, irrevocable trusts are oftentimes used to avoid transfer taxes at death. There are two layers of tax to be aware of. There's the potential for a state level death tax and the potential for a federal level estate tax. And they operate independent of each other. So you have to be mindful of both. In Pennsylvania, for the privilege of living and dying in our great Commonwealth, they tax you one more time on the way out, right? So there is a Pennsylvania level inheritance tax when a Pennsylvania resident decedent transfers assets at death. And it applies to all assets that a person owned or controlled at death. The only exempt assets from the PA inheritance tax are life insurance. So the insurance lobby did a pretty good job there. Life insurance is not subject to the PA inheritance tax. Real estate located outside of Pennsylvania, so my Jersey Shore property is not subject to PA inheritance tax. And then IRAs and 401ks if the decedent was under the age of 59 and a half. So if you're 60 or older, IRAs and 401ks are subject to the PA inheritance tax. There's no exemption from the Pennsylvania inheritance tax. So technically dollar number one is taxable in Pennsylvania. Now we have an inheritance tax, and what that means is that the rate of tax depends on who the beneficiary is. So the relationship of the beneficiary to the decedent. So there's no tax between spouses in Pennsylvania. So the rate of tax to spouses is 0%. It wasn't always like that, by the way. Up until the, I think, mid or late 80s, there was actually an inheritance tax in Pennsylvania when you left assets to spouses, but not anymore. The rate to children and grandchildren and parents and grandparents, so up and down that lineal line, is 4.5%. The rate to siblings is 12%, and the rate to anybody else in the world is 15%. You can whittle away at that tax with deductions. So you get to take deductions for things like funeral expenses, final bills, attorney fees, accountant fees. Those are all deductions against the inheritance tax, but the tax is due 9 months after you pass away. There is the opportunity to get a discount against the tax. So there's a 5% discount if your executor pays it within 3 months of death. But it's not 5% that wipes out the 4.5% rate, unfortunately. It's 5% off of whatever the tax amount is. So usually when I'm advising executors and helping people settle estates, we like to try to make that prepayment because it's free money. But that 5% discount is available if you make that prepayment at 3 months. So that's the Pennsylvania inheritance tax. Again, no exemption from it, and those are the rates. There is also the potential for a federal level estate tax. Just like the inheritance tax in Pennsylvania, it applies to all assets that a decedent owned or controlled at death. There are no exempt assets. So life insurance death benefit is taxable, retirement accounts are taxable, and the top estate tax rate is 40% right now. So it's quite significant. There is an exemption though from the federal estate tax. It is currently in 2024, it's $13.61 million per person. So what that means is that if your exemption is under 13, or if the value of your estate is under 13.61 million, you don't have to worry about the federal estate tax. That number though, like I say, is higher now than it's ever been, and it's set to go down. So in 2016, the Tax Cuts and Jobs Act doubled the exemption amount. It's indexed for inflation, so it goes up a little bit every year. But what happened is that they didn't have the votes in 2016 to make it permanent. So the way that the law is written is that beginning January 1, 2026, the doubled amount will go down. And current estimates are that it'll go down to about $7 million per person. So we're in a bit of a use it or lose it situation right now with 2026 coming. I know, Bill and I were chatting the other day, and we were saying, do we think it's actually going to go down? The exemption has never gone down before. We had a year where we had no estate tax, which was sort of an odd, sort of funky year. There's reasons for that, but we've never had a situation where it's gone down before. But with that said, in order for it not to go down, it will take an act of Congress, and the president will have to sign it. So there will have to be some agreement among the executive and legislative branch to not let it go down, because the way that the law is written, it will go down even if they do nothing. So currently, we're planning under the assumption that it will go down. I would be pleasantly surprised if it didn't, but the way that the law is written, we have to operate within the law as it's written today. A couple of years ago, when President Biden proposed the Build Back Better Act, he had proposed to lower the exemption right away. It did not go through. That piece was not included in the legislation, but there was it was drafted, and it was a real threat anyway, but it didn't actually happen. So we'll see whether Congress will allow it to go down or not, but the way that the law is written as of right now, it's set to go down.
And the way Congress typically acts, we'll know on December 28th of 2025, right?
Yep. Portability is a relatively new concept. It's been around for a few years now, but if you did your estate planning in the early 2000s, mid 2000s, your planning may look a little bit different. Portability is the ability of a surviving spouse to reach out and grab the unused estate tax exemption from a predeceasing spouse and add it on to their own. So just by way of an example, if we have a husband and wife, husband passes away, leaves all of his assets to wife, he's used none of his $13.61 million exemption in that example, because there's a marital deduction for everything going to the spouse. The spouse in this example, the wife, has the ability to file a return with the IRS to reach out and grab his unused $13.61 million and add it on to her own. So she would have, roughly $27 million of coverage at that point. You have to actually elect it. You have to file an estate tax return and check the box. But if you do, portability allows a spouse to port over that unused exemption and add it onto their own. So it's important. If you have a spouse that's passed away, there are time limits for when you can do it, but it's something to think about. So portability is a concept that allows surviving spouses to be able to use unused exemption of a predeceased spouse. We didn't always.
And Andrew, does a TOD or a transfer on death designation avoid the lifetime exemption or avoid inheritance tax?
It does not. No, it's a snapshot at death of what a person owned. So it's not just estate assets. So a TOD designation would make it a non-probate asset. It's not going to flow through the will. It's going to go by beneficiary designation. But from a tax perspective, the estate will still potentially owe inheritance or estate tax on it.
And it doesn't impact it doesn't avoid the annual or the lifetime exemption.
It does not. No, it would use up exemption when you pass away to cover it. Yeah. Yep. When you think about the estate tax, you also have to just be mindful of the gift tax. The gift tax is the companion tax to the estate tax. So what Congress does not want is somebody lying on their deathbed, giving away all their assets and dying the next day and saying, hey, I didn't own anything, you can't tax me on it. So a long time ago, Congress came up with the idea of a gift tax. The gift tax rate is still 40%, and you still have that $13.61 million exemption. So you only get to use it once, so you have $13.61 million that you can transfer either during life or at death or some combination between the two. But if you make gifts during life, you will use up some of that $13.61 million exemption. Most folks are familiar with the annual exclusion, is what we call it. Currently for 2024, that number is up to $18,000 per year per person. What that means is that you can give up to $18,000 per year per person without using any of your $13.61 million exemption. So Congress is not really concerned with, Christmas gifts, wedding gifts, birthday gifts. They say, if you're giving less than $18,000, you don't have to report it, and you're not going to use up any of your exemption. But if you go over that, per person, then you have to start using up some of your exemption at that point, and you have to report it on the gift tax return. So with all that said, that tax primer as a background, what do we do about it? If we're concerned about either inheritance tax or really estate tax, because the 40% estate tax rate is significant, what do we do about it? There are three ways that I tell clients that you can deal with an estate tax problem. I don't care what anybody tells you or what you read about online, everything falls into one of three categories when we're thinking about dealing with an estate tax problem. The first way that we deal with an estate tax problem is by making your estate smaller so that there's simply less to be taxed at the time. Typically that involves, lifetime gifting. What that means is that we take assets out of your own name and we gift them typically into a trust, typically an irrevocable trust. It gets it out of your name, and the hope is that whatever you've gifted appreciates in value down the road and is never subject to estate tax again. So if I wanted to take $2 million and gift it into a trust, for a spouse, for example, I am using up $2 million of my exemption, but if that $2 million has appreciated in value between the time I die, between the time I gift it and the time I die to maybe $5 million, that additional $3 million of appreciation happens free of gift and estate tax and inheritance tax. So making my estate smaller is one way that I deal with an estate tax problem. Another way that we deal with it is with life insurance. So we own life insurance inside of an irrevocable trust, and the idea is that it's not includable in my estate, and it can provide liquidity to pay the taxes. And then the third way that we deal with an estate tax problem is with charitable planning. And there are some charitable trusts that we'll talk about in a minute, but just general charitable gifting can reduce an estate tax bill. But this slide is all about irrevocable trusts. So again, in my example, if I create a trust for my spouse, I can gift assets into that trust during my lifetime. It is creditor protected, so my spouse's creditors or my children's creditors do not have access to it. Divorcing spouses do not have access to it. It's forever protected from creditors of the beneficiaries at that point. But they can't be easily amended or changed. They're irrevocable for a reason. With that said, Pennsylvania law is surprisingly flexible in modifying or amending or even terminating irrevocable trusts. Pennsylvania law says that a family can sign what's called a non-judicial settlement agreement or a family settlement agreement. And you can actually change the terms of an irrevocable trust as long as everyone who's a potential beneficiary agrees to it and signs off on it. You can also get a court order if somebody won't agree to it and you really want to change it. You can have a judge do it, but it's not as easy to amend or change an irrevocable trust like it is with a revocable trust. Irrevocable trusts typically cannot benefit the grantor. So they typically cannot benefit the creator of the trust, only third parties. So I have to create a trust for someone else, whether it's my children or my spouse or my family members. I can't name myself as a beneficiary of it if I wanted to be creditor protected and if I wanted to be out of my estate for tax purposes. So when I'm thinking about this, I have a lot of clients who say, I want to make a gift into a trust. I want to get it out of my estate for tax purposes, but I'd still like to have some access to it because, it's my money. Oftentimes in those situations, we're thinking about spousal trusts. So on this next slide, where it says common types of irrevocable trust, the third bullet there says spousal lifetime access trust. A spousal lifetime access trust is just a trust that one spouse creates for the other. Typically that beneficiary spouse is the trustee and the beneficiary of it. So if I take assets, I take $2 million and I gift it into a trust for my wife. She's the trustee of it, so she controls it. She's also the beneficiary of it. If she wants to pull money out of it to make an addition to the house or to go on vacation or buy a second house, she can do that. And I retain indirect access to it via my spouse. Now, I can't be a beneficiary of it because if I was, it wouldn't be creditor protected. It would come back into my estate for tax purposes. But one spouse can create a trust for the other. And actually, both spouses can create trusts for each other. So husband create a trust for wife, wife can create a trust for husband. There's some rules. We have to be careful for a variety of reasons when we do that, but spouses can create trusts for each other, which gives both of you access to them. It gets all of the gifted assets out of the estate. So spousal lifetime access trusts are one way of making the estate smaller while still retaining some of that indirect access to the trust assets via your spouse. Life insurance trusts used to be very, very common when the estate tax exemption was much lower, are still common for folks who have either exposure now or will have exposure when the estate tax exemption goes down. An irrevocable life insurance trust or an ILIT is just a trust that's its sole purpose is to own an insurance policy. You say, why would I do that? If I own insurance personally, when I die, the death benefit is includable in my estate for tax purposes. So if I have a $5 or $10 million death benefit policy, I throw that into my estate pot. I throw in the value of my house. I throw in the value of my bank accounts, the value of my business. Everything goes into that pot, and whatever's over the 13.61 million or over the $7 million number when 2026 gets here, that's all subject to a 40% estate tax. So one of the easiest things that you can do if you have an estate tax problem or will have an estate tax problem is just stop owning life insurance personally. Take that death benefit out of your estate, put it into a life insurance trust, and as long as you make that gift and live 3 years, the death benefit is not includable in your estate for tax purposes. So an ILIT is a very common estate tax planning tool. There's a whole alphabet soup of other types of trusts that are irrevocable and common for different purposes. Again, everything you do should have a purpose. Intentionally defective grantor trusts or IDGITs are trusts that are includable for income tax purposes in someone's on someone's income tax return, but out of their estate for estate tax purposes. There's charitable trusts, charitable remainder trusts, charitable lead trusts. There's grantor retained annuity trusts. We call them GRATs. We really don't have time to dive into all the details of all these, but I just put them out here for you to look at and for your own, education. The one I do want to hit on just briefly is special needs trusts. A special needs trust is a trust that is specifically written to benefit a person who has special needs and who is qualified for governmental assistance benefits. Most governmental assistance benefits are means-based programs, which means that the assets of the disabled person have to be spent down or used up before they can qualify for things like Medicaid. A typical discretionary trust, like I talked about earlier for my daughters, that just get them a little bit older, pay them for their health and their education, that would be a countable asset for a special needs beneficiary. A special needs trust is written in a way that it does not disqualify them. So if you have somebody in your life who you're thinking about leaving assets to who has special needs, you want to make sure that whatever you're leaving to them is directed into a special needs trust. And as long as that happens, it will not count against them. It will not bump them off of their benefits that they're receiving.
Andrew, we just went through a lot of different types of trusts, and maybe we can spend a little bit of time of who do we name as a trustee? Because that's often a very challenging conversation. And sometimes people think, oh, just because I have a spouse, maybe they're the best resource, but they may not be, right? I think it depends on who has the propensity, who has the appetite.
Yeah, absolutely. Yeah, a trustee can either be an individual, like a family member or a friend, or a corporate option, like a bank or a trust company. What I would say is if you're going to name an individual, it ought to be somebody that you trust, somebody who's responsible. There's really three main jobs of a trustee. The first job of a trustee is to manage the investment assets of the trust, right? So to work with a Fort Pitt to make sure that the trust assets aren't just sitting there in cash. They're invested with an appropriate growth horizon. The second job of the trustee is to make distributions to the beneficiaries at the right times and for the right reasons. The third job of the trustee is to keep the books and records of the trust, so file the tax returns, all the administrative stuff. So it's got to be somebody who's responsible. They don't have to be a CFP or investment professional themselves, but they need to know enough to be able to work with somebody like the Fort Pitt team. As long as we find a responsible individual, somebody who's going to be involved in the beneficiaries' lives, that's good. The other option are corporate options. So bank and trust companies, they all have fee schedules. They do it for a fee. Most of the time, they want to manage the assets. So typically, they're going to pull them away and park them in whatever bank or trust company they're operating. But those are alternatives as well. And you can have co-trustees. So you could have multiple. You could have an individual plus a corporate. You could have two individuals. There's different ways of going about it, but that's a really important conversation as we're thinking about trust.
So Andrew, are there? I'm sorry. Are there
naming a successor trustee?
What's that?
And also naming a successor trustee is important.
Mm-hmm. Yeah, absolutely. If your original trustee can't do it for whatever reason, we want to have we always want to have a mechanism to get a successor in there. Yeah.
So what I was going to ask is, are there general rules of thumb, at least for you, Andrew, about when an individual trustee is appropriate versus a corporate trustee?
Not really. I mean, it's really about who you trust to do it. There's not even really size limitations. I mean, I work with the largest family I work with has about a $9 billion net worth, and their family trusts are all managed by 2 family members, a lawyer, and a CPA, and they're all individuals. So there's not even a size limit on it. It's really about who you trust to carry out your wishes the right way. So yeah, I would, it's really about a conversation, with your attorney to say, who would be the best person to plug into this spot. Yeah. The last thing I'll say, this is my final thoughts. If you did estate planning a number of years ago, you may have old revocable trusts. You may have old life insurance trusts that were very appropriate for you at the time they were written. The law has changed. Laws have changed, since the early 2000s, for example. You very well may be able to simplify some of your estate planning documents. You may not need those old revocable trusts or old life insurance trusts. But if it's, I usually recommend that you review your documents every 3 to 5 years. Pull them out and review them. Call you. I always tell my clients, just call me and I'll tell you what they say if you don't want to read them. But it's good to keep these up to date. So.
Yeah, I know you and I, Andrew, were talking about this the other day. when I started my career, the federal estate exemption was much lower, and so AV trusts were much more common. And a lot of the language would say, fund the trust up to the exemption. And if you and anyone on this webinar, that sounds familiar, and your estate plan says fund it up to the exemption, and you have less than $13 million, that means you're going to fully fund the trust, and there's not going to be anything left in the A trust, right? So being aware of that risk and not creating a pauper for your spouse.
Absolutely. Documents are oftentimes written by formula. And so, if the fundamentals of the formula have changed, that's going to impact the result that you get as well. So, it's not something that you do once and you're forever done. So it is important to keep these things up to date and review them.
So we kind of answered questions as we were moving through this presentation. So I think if it's okay with everyone else, if your questions weren't answered, there was a lot that were submitted ahead of time, there was a lot submitted during, tried to pick out ones that kind of flowed with the discussion. Reach out to Bill, reach out to me, reach out to your Fort Pitt financial advisor. Andrew is always available for questions. We will be sending out a recording of this, and I do want to just outline before we end today, we do have a couple of other webinars coming up, how we choose stocks, which is always a very interesting topic, and when to hire a financial advisor. Not everyone thinks that they need a financial advisor, just like not everyone thinks they need a trust or estate planning attorney. So 2 great topics coming up. Andrew, I really appreciate you spending the time with us today, and look forward to reaching out and answering any additional estate planning questions that people may have.
Yeah, no, that sounds great. I'm happy to be a resource. Anyone who has questions, you can call me, email me. I'm happy to speak with you. So I appreciate you having me on today.
Thank you, Andrew.
Yeah, thank you both.
Don't forget to download the handouts if you want copies of what we talked about today.